You hear me? All right, I'm really loud. So usually I tell people I don't even need a microphone when I'm up here. And I like to walk and talk. It's one of the things that makes my mind jog. And I know we're in the afternoon and it's a rainy day. And of course we'd be stuck in some kind of crazy weather coming from all over Texas and the US. It's fitting for our seminar we're here on today. And some of you in the audience I know have heard me speak at other seminars, typically on things from ethical public adjusting to changes in policies. I've talked about water damage. Show of hands, how many have heard me speak about trends in policies? I got one out there. Okay. Well, why this is important is I first talked about trends in policies and insurance back in 2018. And this was 1 year after the law changed in Texas in 2017 regarding notice, which is now Florida has followed, right? Some 4 years later on. And we were predicting things that we may see on the horizon based on the rumblings in the insurance carrier world and the likes of Zell and the what the hell seminars being put on by, as you know, engineers that are favored by the insurance companies in Texas, such as Nelson Forensic and Engineering, as well as Stephen Badger, who you all know is the big bad wolf, hired on the defense side a lot of times to push agendas in Austin, right? So I reached out to Badger, told him I'm going to be speaking at this seminar, and I said, hey, share with me all your policy changes that you are trying to get passed in Texas. I'd like to see them because I want to put them up and compare them to what we had predicted 2 years ago. So he did. So, yes. And with that, he said, here's all this information. Please tell everybody that my law firm had a hand in drafting all this language for the carriers, and we did it based on all the abuses we've seen in the industry, right? I said, sure, I'll be happy to state that. Now, anybody who knows me, I've been doing this for almost 20 years now. Next year, it'll be 20 years. I've been a policyholder attorney in Texas that long. I've tried cases. I've worked on cases from Texas windstorm all the way up through commercial litigation, residential, small cases. There's no case too small for me. I take it if it's a good case, if it's a good client, I'm taking the case. And I am a diehard advocate for the plaintiff side. So when I see people, carriers, opposing counsel, engineers on the other side messing with the laws in Texas and messing with the policies, it pisses me off. It makes me very mad. I'm probably, if I said, does anybody in here work for TDI? Do we have a Texas Department of Insurance person here? Unfortunate, right? Part of me is they are the agency in Texas that's supposed to guard the consumers, help prevent against certain things. I feel like their target is on the wrong people at times, right? They're looking at the wrong side. They're looking at contractors, looking at public adjusters, they're looking at attorneys, they're looking at insurance fraud. They're not really looking on the other side of that docket, which is insurance. So we're going to go through, and I'm going to show you what over the years I have seen since starting in 2002 as a policyholder attorney for the Austin law firm. I'm now with Merlin Law Group, and show you kind of the trends I'm seeing and what we need to do to be prepared about them. What we're going to talk about today is duties after loss, appraisal, cosmetic roof exclusions, suit against us, and notice of claim provisions. Another one I'm going to add to the very end of this is something that came up yesterday as I was amending these slides, adding the stuff that Stephen Badger had sent me. He had sent me a couple of documents about water endorsements. Everybody here, anybody who lives in Texas knows we were all affected in February from the winter storms, right? We got pipe claims, we got frozen claims, we got pool claims, we got all kinds of claims. And what we're seeing as attorneys, now it being 90 days post that storm, is we're seeing a lot of people with insurance policies that have a cap on their damages. So even if you had a sudden accidental discharge of water that's covered under your policy, there's a lot of policies that had these little hidden caps of $10,000. So you've got people with enormous estimates to replace the damage to their home from the winter storms, and they're being capped at 10 grand. That's it. That is a change in the policy. That is something that is relatively new. People didn't know about it. Agents didn't know about it. But when you ask the likes of people like Stephen Badger, why do we have this? They say, well, because we were trying to stop claims that were being filed for slow-term, long-term leaks, things where people had these damages extensively, right? So we'll talk about that too. So do you think these changes that we've seen over the last 20 years are pro-carrier or pro-policy holder? Anybody think it's pro-carrier? Anybody? You think it's pro-carrier? All right. It is. They're not pro-policy holder. Every single change in the policies in Texas have been pro-carrier. There is nothing beneficial that has been added to a policy in Texas, as you know. No additional benefits, no additional duties under loss, nothing whatsoever. No affirmative action or behavior. There has not been once. So since I started in 2001, the rights have been dwindling away. So what we have, here is where I go back, and I've gone to TDI, and I've looked at their archives, because you can go and see and compare any policy you get with TDI to see if it's something that is a file and use type of a policy. Is it allowed? Is it approved? What you're seeing here is when a carrier submits a policy to the Texas Department of Insurance, they have to outline what the current language is that they're seeking to change and the proposed language. This one you'll see is in regards to appraisal. You have this one paragraph here, typical appraisal kind of condition. This is the proposed change by the carrier at the time, and all this underlining are things that they want to change. In this particular form that was in TDI's possession, there is 3 pages worth of changes to an appraisal provision. All of this. Now, we're living that, right? How many of y'all see nowadays in your policies these new appraisal provisions that have every kind of requirement from outlining the scope, outlining the items, putting your actual cash value, putting your depreciation, making sure your appraisers are qualified, making sure your umpires are qualified. Everything has been written in now for the appraisal, when it typically used to be a paragraph long. That's it. Very simple. Here's another one. Foremost, which is Division Farmers, right? This was one of their policy revised printings we look at. They were talking about dwelling policy. The vacancy clause was added. Another 15-year-old, if your roof is 15 years or older on your roof limit, anything in red was added. They crossed out what they wanted. They added additional ones. And again, we go to the appraisal provision. They keep messing with appraisal. So in this case, the same thing. They're talking about what can be appraised, what's component, what's the claim loss, and it goes on forever. And nobody at TDI is doing anything about this. There's no rewriting, there's no reduction, there's no warning, hey, hold on, what are we doing here? And why is that? Well, here's another one. This is another policy with the redlining on the duties after loss. Now, if you look at this, I found this ironic because this is our duties after loss and insured's duties after loss. They've written every single thing in here they want your client to do. Give us prompt notice to your agent, report any information, give us accounting records, billing, invoices, produce receipts, give us access as reasonably required to the property, proof of loss, talks about examination under oath. We want the amount you actually spend in repairs and to replace the property, everything on that. They go on and on and on and on. So they've added a million lists to your duties and little things to do. And again, they mess with the appraisal provision. Here, they add AAA in. You have this AAA provision. They have sued against us. They mess with every single thing in this policy that is beneficial at the time to the insured is now more beneficial to the carrier. And it goes on and on and on. So do you smell a rat? Yes, I do. I've been long enough practicing to kind of see it do this. I remember when I first became a licensed lawyer in 2002, the year after I started working, they allowed insurance companies in Texas to go from a 3-form policy in Texas to 300 different forms policies in Texas. This was a big contentious issue because obviously before then you had HOA, you had HOB, you had HOC, you had the common commercial policies, and you pretty much knew what you were going to see if you had a client that hired you. You knew what it was going to say. You knew an HOA and an HOB were different. HOB was an all-risk policy and HOA was a named peril policy. You knew the HOC was a variation almost of a commercial policy. It was a better policy. Now, post-2003, file and use. Carriers just have to file what they want changed. They have to file their policy that they're going to use, and they can start using it immediately. There are 300 different forms. You can't even keep up with them. I will tell you, if I would put every example of a form into this PowerPoint, we'd be here for days. There's so many. Every carrier has 20, 30 different forms, and there are hundreds of carriers out there. Not two are alike. You've got rate increases. They never decreased. Has anybody heard of a decrease in homeowners property rates or commercial property rates here in Texas? No. As a matter of fact, we have the highest in the nation. The highest. Increased premiums, higher deductibles. That's another thing that's changed. As you and I know, post-Ike, most of the insurance policies went to a higher deductible for your windstorms, your hailstorms. You're looking at 2%. I've seen them even higher than that. So every year, the premium's going up. Every year, your policy limit is going up. And every year, your deductible is going up. Those are the things you can guarantee in Texas. Now, when you ask how did we get there, some in the industry would say they got there because there were too many lawsuits filed, too many filing of claims, increased number of public adjuster filing claims, increased policyholder attorneys filing frivolous or fraudulent claims, and exposure and risk of storms. That's what they say, right? Even on these years where we have Hurricane Harvey floods, we have other floods, we have hurricanes, tornadoes, guess who makes profit every year? What industry makes money every single year? Doesn't matter if there's 20 hurricanes that hit the United States. They always make money. And we know this. And it goes way back. I'm talking 2008, 2009. I can see people I've worked with for a long time that I knew their face. People that used to be on the other side of me in cases who are now on this side of the log. As I say, come to the light, on this side of the force, right? They're now here. Looking back and seeing where are carriers making their money? Well, there's only a couple reasons that we can take. McKinsey Consulting, we can thank for this, right? When they had to produce all their information against Allstate and show us kind of what they were looking at. You can save only a couple things on the underwriting side. You can mess with the premium, right? That's what you can mess with. Premium, the rate, which is only so much because you can't go up only 10% a year. This is where you are. But the only other place to save money is in underwriting, is not in underwriting, it's in claims handling. Instead of paying 90% of the dollar on the claim, only pay 60% of the dollar on the claim. Don't pay it all. That's one way. Then you guys need to instruct your adjusters, teach your adjusters how to identify exclusions. So how do you do that? How are you going to educate as an insurance company? How are you going to educate your adjusters to look for damage that would be excluded under a policy? Well, you bring in the likes of Nielsen Engineering and you hold these cute little seminars where you say, hey, we're going to teach you how to look at this roof, or we're going to show you on these roofs what is considered to be pre-existing, a defect, an installation issue, old damage. I just took a deposition of an Ingle Martin adjuster last week, and I just love the fact that he liked to tell me, well, this is an old dent on this roof over here. And this one right here in red, this is a new dent. This is an old dent. This is old damage. This is new damage. This looks like this tear in this TPO was foot traffic because it looks like someone stepped on a nail, and that's the Achilles heel of a TPO roof is, you know, when people step on nails on TPO roofs. Really? It wasn't the 3-inch hail that came through Carlton, Texas 2 years ago that caused all of this damage? No, it's old. We pulled CoreLogic. We went back 10 years. There were all these storms. And you see this splatter mark's new, and it's got like all the paint's new. You can't see it. This is oxidized. So I can't tell you. Where'd you learn that at? An engineering seminar? What the hail seminar? Where'd you go learn that? So it's been working, right? Like carriers had to figure out, where are we going to get more money from? We're going to get more money if we've got to educate our own to go out there with the eye to deny, to go out there and find reasons where we can also not pay the claim. How many of you here are public adjusters? All right. Tell me, have you seen an increase on your claims on the carrier side of a carrier's adjuster obtaining an engineer report during the claims handling? Every time. It never used to happen. 5, 6, 10 years ago, unheard of. Right. Never. 10 years ago, you didn't have. You might have had Rimkiss on one, a Hague Engineering on one. The typical players, you'd have a couple times. All right, maybe if there was an issue. It wasn't an automatic. Every file I've seen that comes across my desk, even the smaller one, this is the protocol. We need an engineer, not an engineer, insurance company. We're not going to have any employees that work underneath us anymore. We're just going to outsource everything to independent adjusting companies. So let's go hire the independent adjusting company so we can say it's them, not us. We have no training. We don't train them. We don't have training materials. All our training and stuff, we rely on them to train their people, right? This is this extra layer. So let's hire the independent adjuster. Independent adjuster, you do everything. You're the eyes and ears, you're the boots in the ground, you're everything. Then you report back to us. They go out there, inspect, they do everything, come back to the desk adjuster and say, here's my evaluation, here's my suggested reserve. What would you like me to do? I believe that we should probably hire an engineer because I've seen some old damage up there, or old dents, or old hail, or it might be like this. Yes, please do that. Next thing you know, engineer comes out. Now, it's not just Rimkiss. It's Unified Building and Science. It's Rimkiss. It's the D one. The D one. Yes, Donan. Yeah, we've got that one. I just saw one. Kevin Rogers. Woo, had him on one. I thought, wow, this is interesting. This person's been out being an engineer for 3 years, and he's got all these assignments from carriers, just left and right. I see his name on every file, right? That's their new thing. This is what we're going to do. Well, where's the law that we get to sue those engineers? That's what I'd like to know, because I've looked into it. Let's talk about pro-consumer laws. How about this? Pro-consumer laws. Well, how about we have the ability that if we believe that you wrote a report that the insurance company relied upon to deny the claim, that was consideredly outcome-oriented investigation, it was a Nikolai versus State Farm matter, we get to sue you too. Let's put you in there, right? Well, in Texas, unfortunately, we can't. We can't unless we have a counter-engineer, like a med malpractice case, where they're willing to testify, say, and state in a report that that report of that engineer is fraudulent, not accurate, just like you have to do if it's a malpractice case. Bullshit. That stuff needs to change quickly, because that's what's happening. They're relying on engineer reports that should not be relied upon. Well, the truth? Here we go. We all know this. This is an old slide, been recycled a million times, I'm sure, but this is an insurance company. Well, we don't break the rules, we change them. Every year, policies are changing, because that is the foundation of every single claim. That is the foundation of what public adjusters do. It's the foundations of what policyholders do. Everything stems from the policy. So that's how they're going to try to do this. If they can't get it done that way, they'll try to legislate it, right? They'll try to either go to the legislature in Austin and make law, or they're going to change it right there to write it into the policy. The truth is this. It's not fraudulent lawsuits. We do have increase in storm severity. We have these crazy storms like last night that are happening. We've had hailstorms. Vortex. Dallas must be in the vortex of hail. That's what I know. Every time I turn around, Dallas in that area is getting pummeled by hail. We have less tenured and experienced carrier adjusters. That is the truth. Now, the two guys I deposed last week, Ingle Martin adjuster and AM Trust adjuster, they had been working for 30 years. They were so indoctrinated into 30 years of being on that side. But now you're dealing with the person that used to deliver pizzas is now the building consultant on the case that goes out to the house to do the inspection for TWIA, right? Or you've got the other person who is fly-by-night. I took one, I kid you not, I took a deposition of a guy out of Florida, came over here to adjust a claim. He was here for 2 weeks. It was a Harvey claim. Comes due in here, he got paid, and I have to remember this because it blew my mind that he told me. I want to say he did 300, was it 300? I'm looking at my, 397 claims in 3 months, was it? 397 claims in 3 months, and do you remember how much he got paid that he told me in that depot? $250. This is good. The drive-by, this is called the drive-by adjuster, right? Like, this is how it is. He said, hey, how I get paid the bigger the claim, I get more money. That's what, right? So I have an incentive to find more damage on us. I have an incentive to find more things because I'll get paid more. So I'm this honest adjuster because I didn't do that. No, you're not. You figured out the system. Why would you spend more time at my client's house to find more damage to which you might get paid a little more when you can get a minimum $250 a file if you keep it under $10,000 and you can hit your 397 claims in 3 months. It was like 397, someone do the calculation, times 250 bucks. Yes, in 3 months. That's not bad, right? Shit, we should all hang it up. Let's all go and do that for a living. But when the hurricane hit Florida where he lived, he tucked tail ran. He got out of there, him and his van, drove all the way back to Florida. They were going back because it was easier to go make money in Florida where he lived because he could do it out of his house. That's exactly what he said in the depot. So is that happening? Every day it's happening. Increased use of building consultants, non-licensed adjusters, drinking the purple Kool-Aid, industry seminars being put by coverage counsel and career engineers. Man, there is a witch hunt. 10 years ago, 11 years ago, 15 years ago, lawyers were not the enemy, public adjusters were not the enemy, but you're the enemy now. And everybody's coming after you, right? They don't like that. So, duties after loss. Increase of insured's duties, decrease of insurer's duties. Proof of loss requirements are automatic. There's no requirement of a duty for an insurer to inspect anymore. That's mind-blowing, right? When I first started as a policyholder attorney, I remember reading a State Farm policy. Have it? State Farm policy used to have, under their duties after loss, say, our duties after a loss. And they're talking about their own, not the insured's. To begin a thorough and reasonable investigation. Inspect the property. Respond within 15 days. It was basically mirrored off of the insurance code. You will not find the word reasonable, thorough, or even inspect the property in a State Farm policy anymore. The only duty under a State Farm policy in Texas is one sentence. Our duty after loss is, anybody? Does anybody know? Huh? It should be, right? Begin an investigation. As broad as that. And when they take you to trial, just so you know, their position is they fulfilled their obligation under the insurance policy because their insurance policy only required them to, quote, begin an investigation. That's it. We can do an adjustment over the phone. We don't have to go to your house. We can send no one. We can deny it flat out. We just have to begin it. We don't have to finish it. We don't have to end it. We don't have to do thorough. We don't have to do reasonable. This is one of the new duties. This was, I'll give this credit, as he wanted me to Stephen Badger, as he said. This is one they wrote for one of their policies, their carriers. United Specialty Insurance Company now has the following. Notice of loss and duties in the event of a loss or damage. B is the one to look at. Give the company prompt written notice of a loss. For losses caused by windstorm, including hail, in no event will any notice given more than 365 days after the policy expires, terminates, or canceled be considered prompt. Notice should include a description of the property involved, description of how, when, and where the loss occurred. This was his attempt of obviously trying to limit the losses being handled after a year. None of those, oh, latent, we didn't find out till later, here it is a year later. Duties after loss. This is our duties after loss in some carriers. Give prompt notice, notify the police, credit card, protect the property, make reasonable necessary repairs, keep accurate records of expenses, cooperate with the investigation, send to us within 60 days after request your signed sworn proof of loss. One of the scary things that almost happened in this legislative session, y'all may not know about, but we fought against, was a senator here out of League City. David, you know who I'm talking about. Do you know? The senator out of League City that likes to push all these anti-bills. Yes. That guy, right? This, down here, the cooperate with an investigation of the claim. There was some language that tried to get pushed into, in May, towards the end, beginning of May, to get on the agenda to voting about if a insured fails to cooperate with an insurer, then the insurer must cancel the policy. It wasn't even a maybe, it was a must. Not a maybe, not can if they want to, not should. It was a shall, a must. This was huge, right? Because how vague is that? What is considered cooperating? How much do you have to cooperate? What if you keep cooperating, but they keep asking you for unreasonable requests? Like, what is it, right? And then all of a sudden they can cancel you now, and now it's under law that they can? It's not even like in their, it's not the policy. They made it Texas law that you must? That's ridiculous. Thank goodness it got killed. It was not in property claims. I don't know if it got passed in personal injury claims, but I know for property claims, it was absolutely taken out the language that it would apply. Now, more duties after loss, same thing. Our duties after loss, you'll see this. They just have to acknowledge your claim, begin an investigation, and specify information you must provide to us. That's it. Appraisal, hot topics. Prior to 2009, it was rarely invoked. I don't know if any of y'all been practicing before 2009, but appraisals rarely happened, okay? And they only happened for what you said earlier today when the amount in dispute was at issue. If you had a dispute in the amount of the loss and you agreed to scope, so for example, I believe my roof should be replaced. Carrier says, no, your roof should not be replaced. That would not go to appraisal. Other scenario, I believe my roof should be replaced. Carrier says, yes, your roof should be replaced. Well, I believe it should be $50,000. Carrier says, no, it's $20,000. That went to appraisal. That was all pre-Johnson versus State Farm, 2009. So the scope was agreed, causation was not appraised, and court appoints the umpire. 1 to 2 paragraph max. Post 2009, State Farm versus Johnson, we have an exponential increase in appraisal demands. We have complex appraisal provisions, and we have AAA as umpires having to be appointed in certain cases. Here is the old form. If you ever see one of these, you actually will usually see these appraisal provisions in commercial policies. They exist. That's the good thing. In the commercial realm, you're seeing a lot of these. In the residential realm, they're disappearing. So if you find one, it's like finding a unicorn nowadays. They don't exist as much. Again, this is the older version. This is the older version. When you go on, here are some examples of the new ones. So they're going to be, and I'm going to get through some of the ones that Badger sent me because I think they're really important to see because some of them blew my mind. Here is a new appraisal provision. This is so crazy to me. If you imagine how big this is. Like this is a whole page of an insurance policy. All of this, and all I see as an attorney is 3 pages, 2.5 pages. When I see an appraisal provision that long, do you know how many places in there, loopholes there are to litigate and argue over something? That appraisal is never going to remedy anything. It's never going to solve a claim. There are too many gotchas, ways out, errors built in. If you don't follow the policy exactly the way it is, they can set aside appraisal award, they can decide not to pay it. I bet all of y'all are also seeing how many of you have seen in the appraisals that you are doing, carriers not paying the award. So now you're going to appraisal. They could have invoked it. You could have invoked it. Doesn't matter. You go to appraisal. You spend the money. The insured's on the hook for the money for their appraiser. You spend the money on umpire, which you got to pay half of. You get an agreement or you get a sign off, and then the insurance carrier's like, no, I just want, let me see. It's like a restaurant. What can I have on the menu? I'll pay that. And all of this, I'm not paying. Where do you end up? You see a lawyer. You end up in litigation. You got to go fight all over again. So it's not finishing it. AAA arbitration, those are in there. This one is a new one. This is a new one he gave me, which was mandatory abatement. So in this case, if you trigger appraisal, if you have a lawsuit, it's mandatory abated. There's no like condition on it. It has to be abated. Another one, if you file a lawsuit, you cannot invoke appraisal. This is State Farm's policy and position now. If you have a State Farm case and you want to trigger appraisal, you must do so before you file a lawsuit. If you file a lawsuit, you have waived your right to appraisal. That's the State Farm provision. Appraisal, good or bad thing? Both. It is a good or bad thing. Depends. It's literally case by case specific. It's shield and sword mentality. It's a lowball settlement tactic in litigation, I will tell you, because a lot of times what will happen is you could have a great case, a great bad faith case, really good facts, killed it in deposition, you're on your way litigating, and the insurance carrier says, I want to go to appraisal. What? Wait a second, we're already halfway here. We're like about to start trial. No, I want to go to appraisal. That's the way that they try to kill your bad faith claim in litigation. And I also know, I look at Gary, Allstate, you don't work with Allstate anymore, but Allstate, they were big assholes. If you went to mediation and you didn't take their lowball settlement offer at mediation, they would literally tell you in your face, if you don't take this settlement, I'm going to trigger appraisal tomorrow. You're like, what? Yeah, I'm going to trigger appraisal, and then you're going to be fucked, and you're not going to have any kind of bad faith, and you're just going to have breach of contract, and you may get your attorney's fees, and this is the way it is. And it could be the best cases you have. What's right with that? That's not right, right? It's very un-Texan-like. It should be. It shouldn't be very Texan-like. Prevent access to courts and juries. That's how they did it. In litigation, that's how they do it. No court supervision, rules, no rules, professional ethics. Is it being misused? Well, yes. But guess what? Insurance carriers don't like it anymore. They abused it so much against us in Ike days and so much against us after Johnson came out. They used it as a sword all the time. They had convinced courts that after appraisal and you pay it, you had nothing. They had convinced every court practically to say, your case is over. No bad faith. Bad faith doesn't exist. Forget the fact that we paid you $0 and the appraisal says you're owed $500,000. No bad faith. So they abused it forever. So now they're saying, oh, well, poor us. We're having so many appraisals against us by everybody and PAs and all these people triggering appraisals. We got to change it. So the way they change it, they go to their policy. So my advice is before you invoke appraisal, always consult an attorney just to ask, is this case good for one? Because you do actually have some rights now. You can sue for your attorney's fees, penalties and interest, and you can go under 542. It's not dead. You at least have that. And guess what? If you go to appraisal and they're not paying your entire award, you get all of your stuff. So if they don't pay the full award, you can sue them for everything. One of my favorite things to sue on, and I hope other plaintiff attorneys will start to do this, I have found it's one of the easier burdens to meet in these cases nowadays. I sue for breach of contract, violation of 541, 542, which is the insurance code, breach of good faith and fair dealing, because that one's easy. They are always breaching their duty of good faith and fair dealing. But these are my favorites. Fraud in the non-disclosure. I love that cause of action. Fraud in the non-disclosure, right? Did you commit a fraud, insurance company, by failing to disclose something material to my client? Well, how about this? I'll tell you what. Endorsements. These little endorsements, cosmetic roof exclusions, Oh, marring. How many people know about farmers' marring provision? Holy cow, right? We got marring in farmers' policies that's being used to be cosmetic. It's cosmetic. There's no puncture, tear, or hole. You don't have a puncture, tear, or hole in your roof, therefore it's not covered under the policy, right? Where does it say that in the policy? Does it? Doesn't. Now, one farmer's policy actually requires a hole, but the other farmer's policy doesn't. There's a next gen and a smart plan. Depending on which one you have, has a greater burden. But there's contradictory information in there. So when you look into this and you go, all right, here's the policies. Cosmetic roof exclusion. This is a cosmetic roof exclusion. We will not pay for cosmetic damage to your roof surface caused by wind or hail. For the purposes of endorsement, here it is. This endorsement, again, ask me if you need it. This is where I get pissed about Texas Department of Insurance. I've said this numerous times. There was a bulletin, 1998 bulletin. Texas Department of Insurance used to have it in their archives. They pulled it down. I have a copy of it. It says, in a residential case, if you have a cosmetic roof exclusion, it must be signed by the insured, and there must be a premium reduction. Those things, two things have to have, or it is void. That's residential cases. That is the rule. That's the law. That's the way it should be. Yes? I have no idea. It's 1998. Email me. I'll give it to you. And it has those two requirements on residential cases, is that you must have a signature from the insured and you must give a premium reduction. If you don't have that, it is not valid. I actually have a State Farm case that has a signed exclusion and a premium reduction that I've saved all these years to show if you want something like this, this is how you do it, right? There you go, premium reduction. For a reduction in premium, your policy is changed to the following. This is notice. You have to give notice. So guess what? If they are telling you that they are denying your claim based on a cosmetic roof exclusion and it doesn't exist, it's some marring bullshit or it's some other kind of no puncture, no hole, that is fraud in the non-disclosure. Your insured probably had no idea. The agent, I promise you, had no idea. And those are important things to point out. So here's one. This is new, okay? In 2018, the insurance industry introduced this cosmetic roof damage. This is the old slide I had 2 years ago. Now, it's talking about what is cosmetic. It says without limitation, cosmetic damage is without limitation, splatter marks on oxidized surfaces, dings, blah, 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 it goes on through. The exclusion does not apply to metal roofing that is intended to be decorative. Now, here is what some of them say. Again, cosmetic damage means only the damage that alters the physical appearance. Does not allow immediate, this is the buzzword, sorry, let me go back. Immediate penetration. That's going to be litigated, right? What's immediate? Was it long term? Was it immediate? How long was this leak? All those things. Splatter marks, oxidized surfaces, blemishes, here we go, the same thing. Marring, this is the farmer's one. Marring is a disfigurement, blemish, discoloration, scratching, chipping, cracking, weathered, over time, continues to go. Marring is the following, caused by a loss. So here we are. Does it have to be damaged to the structure or functional? No. Does physical damage include alterations to the physical appearance? Yes. You can have physical damage and you can have physical appearance. And here's the question. What if you have damage to the roof but it's not leaking? Is it still damage? Is that cosmetic only? Here's some, 2 old dents mixed with new splatter marks. That was one of my files. 2 old dents mixed with splatter marks. That's the adjuster's comment. Here's another one. 2 new hail impacts with accompanying splatter. This is 3-inch hail. This is this huge hail that hit this area. Outline to accentuate, he's writing. This is on a TPO roof and a metal roof. Tear in TPO appears mechanical, probably from stepping on a nail or screw. Because we're all up there walking all the time. That's a common thing. The Achilles heel is what I was told. Large splatter mark, no punctures. No punctures kept repeating itself. Well, guess what? This policy that this particular church is under doesn't have a requirement that you have to have a puncture or a tear or a hole. It was an all-risk policy. All it said is you must have hail damage that allows rain, sleet, or snow to enter the building. That's it. In their depots, all they kept talking about is there was no storm-created opening, there was no storm-created opening, there was no storm-created opening. Where in this policy does it say I have to have a storm-created opening? Nothing. Where's puncture? Where's a hole? Where does it say that? Nowhere. Here's another one. This one I really liked. Same thing. Close-up view of hail splatter mark. It's noticeable there's indentions. It says, oh, there's an indention on this single-ply membrane. Okay? So they open it up. They take a view. They remove the splatter mark. This is underneath side. That's the dent, right? Well, you can't see, but maybe there's a tear right here. This is torn. And that's what he's saying. He's like, okay, here is this splatter mark is shown. The blue chalk was applied by this. The indention that existed is impacted. Okay, there's your tear. Look at this. Note the fractured tears in the fascia material. Okay, this is hail impacted related indention into this. But they're saying, nope, there's no coverage for this TPO because there's no storm-created opening. The TPO membrane had not sustained a tear, a hole, or a puncture. But it had a dent that caused a tear underneath it, right? Using their own language against them. More dents, more things. Suits against us, here's one important thing to know. The Florida, when Bush was talking earlier about Florida law, discuss the SOL. This is really important because I'm seeing this snuck in. There, you will start seeing notice of loss. You must give a notice of loss within 1 year from the date of loss. I'm going to show you that at the end. It talks about what's on the horizon. These are things that Badger has obviously shared with me to say, here's what's happening. So there will be 1 year notices of loss that you'll have to do from the date of loss. Most insurance policies now are also having a provision that you must file suit within 3 years from the date of loss. So they want a bookend and a bookmark. They want the beginning and the end to be defined. Suit against actions, here it is. Same thing, comply with the policy, all conditions precedent are used, and you have to make sure that this action here, you're brought 2 years and 1 day from the date we accepted or rejected the claim, or 3 years and 1 day from the date of loss, whichever is earlier. So be careful, don't get caught on those. The new actions, here they are. New burdens. This was arbitration, mandatory arbitration. They're happening. They don't want to go to trials. Access to courts is the problem. What's on forecast? This is it. These I will give credit to the Badger. Isn't that funny? His last name is the Badger. I mean, like, of all things, it reminds me of the honey badger, like the badger, you know? It's the same thing. So the Badger says TDI approved prompt notice. Here we are. TDI approved this. Like, really? Is there like a direct phone, like a phone line, like a Batman line, where he's like, you got a call and it's at someone's desk at TDI that says, hey, I really need you to approve this for me, right? Because I don't know about you, but every time we have a complaint or an insured complains and says, oh, I have a complaint against a person, does TDI ever do anything? Have you ever, I'm serious, has anybody ever filed a TDI complaint against a carrier, an adjuster, or had a client that did that actually got some kind of resolution for the client? You did? Holy cow, tell me about it. Well, yes. That's what I was going to ask. When you've had a client that made a complaint about what's happening on their file, has TDI ever done anything? Yes. They did? Travelers did or TDI? Travelers. That's good. That's rare. There must have been something really, really bad that they were hiding from you. That they didn't want you to see in a claims file, which I'm going to interject and tell you about that. The depot things I'm showing you without disclosing the names of the carriers involved. In the claims file, y'all wouldn't have seen it. Public adjusters, you're not going to get this. But in the claims file, I have these cases right now sitting there. The claims file with Kevin Rogers as the engineer on, there is an email from the in-house adjuster for the insurance carrier to the independent adjuster the day before they're supposed to go meet at the property to go inspect the roofs, okay? And it says to that independent adjuster, hey, tomorrow when you're out there with the engineer, hey, make sure he puts some comments in his report about defects, improper installation, deficiencies, things that exaggerate damages, exacerbate them. It's literally, it's an email. Yeah, that. There is an email.
I think he's looking for the one word.
Yeah. and exacerbates, yeah. and exaggerates, yeah. And so he writes this in this claims file that's produced to us. And it's the day before that engineer has to go out and do the inspection. And the line of testimony goes something along this before he knows this. Because here's another thing. Make sure you read the claims file if you're prepping for a depot, right? Like you should if you're going to be deposed. The question is, you would never tell an engineer to alter their report in any way, right? That would not be something you would do. No, absolutely not. I would never do that. That'd be completely inappropriate, okay? So it would be inappropriate to tell an engineer, for example, to include certain comments based on a policy that would exclude coverage. You would agree with that. That's not reasonable. That's something that's inappropriate. It's not proper. No, I would never do that. I've never done that. Yeah, okay. Well, let's pull up Bates label, blah, 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 blah. What's this? It happens, guys. I'm telling you. Like, the claims files are riddled with gems like this that are in there that nobody's paying attention, they're not looking at, but you know what? They don't want you to find out about it. Oh, well, I sue. I sue them all. So I sue the adjuster, I sue the independent adjusting company, I sue the carrier, and I sue for fraud, fraud in the conspiracy to commit fraud, fraud in the non-disclosure, for those reasons. Oh, hell no. That's something you have to talk to your client about. You got to talk to your client about. If the client wants to take a settlement, it's the client's decision, right? That you have to ethically say it. But there are times where they will offer that so that doesn't come out to see the light of day. Go back? Yeah. Yeah, I know. Yeah, no. This just has come out in the sense of new TDI approved prompt notice. So this 1 year is language that's been approved for carriers to be able to use in their policies. So you will probably start seeing this in some policies. Here's another one. Hold on. Here's another one notice. This is a new one. This also came from Badger. It says the duties in the event of a loss. In addition to your obligation to provide us with prompt notice of loss, with respect to any claim wherein the notice of claim is reported to us more than a year after the reported date of loss, this policy shall not provide coverage. This one just it's a dead. You give notice after 1 year of the loss, you don't get coverage. So that's another language that's been requested to be added. This was another one I always put in there. United Specialty, because he said I could. Badger's like, here's another one. Okay. Appraisal. This is a new appraisal type of information the appraisal retains. Okay, you have to get judge. And it says, hold on. So they talk about this is the appraisal process where you got to elect. Umpire will be made by a judge in the district court in the county where the loss occurred. The appraisal will be set separate values. They go on to this if you fail to agree. I've started to see now in these policies, these appraisals that say, we used to be able to go to any jurisdiction, right? You go to any court to get an umpire appointed. There wasn't a limit. You just had to go to a competent jurisdiction to get something appointed. It didn't make you go to a district court. It would say sometimes a district court, sometimes it just said a court in the jurisdiction. You could go to a county court. Now they're limiting them. Insurance companies are starting to limit them to a district court in the county to which the property is. You're going to start seeing those too. So appraisal protocols, you'll start seeing these. Some of y'all are using them, I know. Chris, this is the one thing I think you told me you've seen these protocols where you have to agree on forms, and this is what you submit. This is a brand new one on overhead and profit. What are we going to do now? I mean, we got to put everything in a policy? I used to remember, not too long ago, overhead and profit was never disputed, by the way. Allstate, as a matter of fact, in Hurricane Ike, gave overhead and profit of 30%. You remember that? They do 15 and 15. 15 and 15. Because? There you go. Well, okay, and now you can't, now they want to say, nope. With respect to any wind or hail claim for a roof service, the company will not pay general contractor and overhead profit to repair the physical loss. The company will consider, with prior approval, making a payment. Like, are you kidding me? That's not Texas. You're allowed to make an overhead and profit. You're allowed to do that. That is what happens. Everybody has it. It's never been disputed before, but all of a sudden it's a big thing now. Overhead and profit is this huge, huge issue. They're writing it into their policies because they don't want to pay it, guys. Here's another cosmetic roof. Oh, yeah. Oh, yes, here we go. So this is a new one. This is the cosmetic roof issues. This is talking about the 15 years down here has been replaced, insured for more than 15 years. It will be the actual cash value. So if you have a roof older than 15 years, there's going to be actual cash value. Even if you have a replacement cost policy, right? Then you've got cosmetic HVAC. They've now put HVACs underneath cosmetic roof exclusions. So HVACs as well are now considered to be a roof surface. How in the world is that? Here we go. Oh, this is the big one. Have you ever seen a policy that says you can't hire a public adjuster? That, right? Well, that's what they're wanting. That's exactly it, because you are correct. This here, yeah, this, yes. So this again, this was given by Stephen Badger. This is on the forecast. This is it. They're not only talking, but there's no, yes. So the Florida people reached out to the Texas people, TLR, Badger, it goes back way back, but Badger was TLR, the Texans for Lawsuit Reform attorney that helped pass the Hale Bill of 2017. And he was consulted in regards to the Florida language. What's crazy is the Florida language is far worse than the Texas language right now. It's bad. There are a lot more duties in Florida than you have in Texas, in other words. But this is the first time I've ever seen something like this. But this is what they're saying. In consideration of the premium paid, it is understood and agreed that a condition of this policy is that insured shall not retain or use the service of a Florida licensed public adjuster to inspect. They want that in Texas. That's what he's saying. And that's the scary thing, though. Think about this. Agents aren't being trained on this. I will tell you, because you depose an agent on a cosmetic roof exclusion, if you depose an agent on a marring issue, they never have been trained on anything like this. They don't even know this happens, right? So, and you know this, policyholders are looking going, oh, my premium reduced. This is excellent. They have no idea what changed in their policy. There's no clue. They don't even get their whole policy to know what changed in their policy, right? So they're going to sneak it in there. So forecast, more legislation reform, increased changes in policy, more attacks on lawyers, PAs, and contractors, more battles in and out of the courtroom. There is one thing I needed to show you, and I'm done. I could not put it on my slide. Sorry. It's important. I want y'all to be prepared. The last one he sent me was a form that had every single thing from appraisal. This is an appraisal provision. I just wanted, it's 4 pages long. And in this appraisal provision, it talks about not only determining actual cash value, but you have to determine what the incurred property damage is. And then you have to disclose any known facts which a reasonable person may consider in the effect of independence, neutrality, impartiality of the appraiser. You have to provide the appraisers with any kind of information, documents, examination under oath, share your file. There is a laundry list of things that you will have to do now for appraisal here. So I'm going to leave it on the stage and you can look at this. But what was important is it wasn't just appointing an appraiser has to be impartial and independent. Now you got to disclose any relationship in the last 10 years, anything they've ever done, their qualifications, any other prior appraisals they've ever done for you. I mean, a ton of stuff. But anyways, if you have questions and answers, I'm here. I don't want to take up any more time. I took too long already. But hope you enjoyed. If you have questions, I'm back there.
Thank you, Rene. Thank you.